Hello friends, welcome back to my channel Academy of Legal Learning. Today I am going to discuss on the topic agreement and contract under the Indian Contract Act 1872. So let's start. The most common way of making a contract is through an agreement. So for an agreement there has to be there has to be either two parties or more than two parties. The parties may agree to do something through their mutual negotiations. So when one party makes an offer and the other party accepts the same, if the other party accepts the said offer, then there arises an agreement which may be enforceable by law. So when this agreement is enforceable by law, it becomes a contract. So if we go to the definition of contract under section 2H of the Indian Contract Act, here it is. An agreement enforceable by law is a contract. So for an agreement to become a contract, it has to be enforceable by law. Now, what do we mean by enforceable by law? It means that when one party to the agreement fails to fulfill his promise under the agreement, the other party can move to the court of law, and the party which had failed to fulfill his promise under the agreement can be held liable for his or her failure to fulfill the promise, and said party may be asked to fulfill his promise or compensate the other party. So, when an agreement is enforceable by law, it becomes a contract. However, it is to be noted that all agreements are not contracts, but all contracts are agreement. All agreements may not be enforceable by law. So only those agreements which are enforceable by law are contracts. Some agreements may not be enforceable by law and they are not contract. For example, an agreement to sell a radio set. For instance, if there arises an agreement between A and B where A agrees to sell a radio set to B and B promises to pay certain sum of money to A in return. So there arises an agreement between A and B, and this agreement is enforceable by law. However, an agreement to go to see a movie together may be a mere agreement and may not be enforceable by law. So the second example where the parties have agreed to see a movie together is a mere agreement and not enforceable by law and hence not a contract. So all agreements are not contracts, only those agreements which are enforceable by law, that means which satisfy the essentials mentioned in section 10 of the Indian Contract Act 1872 becomes contracts. Hence all contracts are agreement, but all agreements are not contracts. Now coming to the definition of agreement. If we look to the definition of agreement under section 2E, every promise and every set of promises forming the consideration for each other is an agreement. So in an agreement there is a promise from both the sides, from both the parties. For instance, A promises to deliver his watch to B and in return B promises to pay a sum of rupees 1000 to A. There is said to be an agreement between A and B. In this example, we can see there is an offer by one party and its acceptance by the other party. The offer is made by A to B to sell his watch, to deliver his watch to B, and in return B promises to pay certain sum of money to A. So there is an offer or proposal by one person and its acceptance by the other. So when one party makes a proposal to the other party and the other party accepts that proposal, there results a promise between two persons, and when this promise between the person forms a consideration for each other, it is known as agreement. Now to understand what is the meaning of the word promise, we have to go to the definition under section 2B. It says, when the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. A proposal, when accepted, becomes a promise. So, as per this definition, when there is a proposal from one side and the acceptance of that proposal by the other side, it results in a promise. And this promise from the two parties to one another is known as an agreement. So it is like a chain. First, we can see that there is a proposal from one party to the other party, and when this proposal is accepted by the other party, it results in a promise, and this promise between the two parties, or this promise from the two parties to one another, is known as an agreement, and when this agreement becomes enforceable by law, it becomes a contract. So these are the three important definitions. The first one is the definition of contract under section 2H, which says that an agreement enforceable by law is a contract. The second definition is the definition of an agreement under section 2E, which says every promise and every set of promise forming the consideration for each other is an agreement. And the third definition is the definition of promise under section 2B, which says when the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. A proposal when accepted becomes a promise. So again I am repeating, first there has to be a proposal from one side to the other party, and when that proposal from the one side, from the one party, is accepted by the other party, it results in a promise. And every promise and every set of promise forming the consideration for each other becomes an agreement, and every agreement which is enforceable by law becomes a contract. Thank you for listening. In my next video, I am going to talk about the essentials of a valid contract and the meaning of void and the voidable contract and some other related topics. Thank you once again for listening.